Whenever you're ready.
Welcome to today's program titled Best Practices for Multi-State Employee Handbooks, the 2025 Playbook. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Mesa. Chelsea, please go ahead.
Thank you so much. And hi, everybody. Welcome to Handbook Season 2025 and happy Halloween. We thought it would be fitting to do this today because there is literally nothing scarier than having a non-compliant handbook. So we love this webinar every year. It gives us an opportunity to really parse through and condense all of the legal updates for 2025 and introduce those to you that are relevant for changing and updating your policies for the next year. And so I am joined today by my esteemed colleagues. I've got Jean Wilson from our Boston office. I've got Sarah Fowler from our Chicago office and Renata Walker from our Atlanta office, who, in addition to being some of the best people I know, are also absolute experts in the world of handbooks. And so if you're working with us at Seyfarth to get your handbooks done, these are probably some of the people you are going to be lucky enough to work with. But that being said, I want to go ahead and kick us off because we have a tremendous amount to cover today and a very short period to do it. Starting with, once we get our introduction done, we're going to talk about some of the federal and state developments that really are going to impact your handbooks and policies as we go into 2025. We decided a couple of years ago to move this to the very front because we know that is the meat of why y'all are here, and so we want to spend as much time doing that as we possibly can. We are going to do a little refresh on the importance of having an excellent handbook, why it's so important to do that, as well as corresponding state addenda, and give you a little bit of insight as to how our handbook and policy team that I've had the honor and privilege of leading for the last several years has been helping our clients, helping employers get their handbooks in tip-top shape. We will close it out today with a CLE code, but also with trends in the law to let you know where we think it's going to be going after 2025 and beyond. We do have a little bit of a crystal ball among the four of us, so we like to try to predict what we're going to see as we dive into 2025 and into 2026 and beyond. So why don't we first dive in and just talk a little bit in terms of the federal and state developments that are going to impact your policies. I am going to talk just a little bit about the federal updates on the next slide, and you can go one more. So we can talk just a little bit of refresh on the NLRB and the NLRA. I know we talk about this probably every year, but the last year has been very, very exciting in this space, and I wanted to give just a little bit on a refresh on the Stericycle decision that all of y'all remember. You know, under the NLRA, obviously, that employers can't have policies that are going to interfere with the rights of employees to engage in union activities or other concerted activities. And we also know that this is going to apply both to union and non-union employees. And as the administrations go back and forth, we know we get a different board depending on who is leading us from a federal perspective. The Stericycle decision that came down a little while back basically was memorializing that this current board is going to be using a standard where policies that may not be unlawful on its face or even have had impact of being problematic in this area could also be unlawful if somebody who is contemplating engaging in protected concerted activity would interpret the rule to have a coercive meaning, just a reasonable tendency to do that. And so it is a very employee-friendly rule, a very union-friendly rule, and we recognize we can look on the next slide, that what we've seen over the last year is the NLRB highlighting areas where this is really going to have an impact. Policies that are going to be likely to subject to scrutiny and challenge, things like confidentiality, electronic communications, things related to complaints, dress code, solicitation and distribution, social media is a real hot button area. So these are things that we really want to be looking at and asking ourselves, are our policies, obviously, are they problematic on their face? Are they restricting access to the NLRB or to unions, for example? Are they prohibiting employees from being able to discuss the terms and conditions of their employment? Are they prohibiting employees, blanket policies prohibiting them from talking to the media? Things like that we know we really cannot do. We have to be very careful about. And so we really recommend on the next slide taking a very hard look at your policies from this perspective and asking yourself as you go, what are you trying to protect with that policy? Is this a policy that's really necessary? And as it's written, is it actually doing what we intend it to do? Can you justify the policy or the rule? And if you can, is that justification in the policy itself? It's always better to kind of get really narrow. That's what the NLRB is going to want to see in 2025, making sure that if we've got a justification, we might as well go ahead and put that or illustrative examples within the policy itself. So it's not just the NLRB deciding how to interpret our policy, but we're actually explaining it right there in the language. And so I do think it really merits a relook at some of those policies that we mentioned on the last page, like confidentiality, social media, solicitation, et cetera, anything that really could have that impact of chilling that protected concerted activity. And we're a really big proponent of savings clauses and disclaimers. I think a lot of employers at the outset were using one in their handbook and hoping that was going to be good enough. I think we've really moved to a place where anywhere we think that there is any question about the interpretation of a particular policy, throwing in that disclaimer language, throwing in that savings clause, just to clarify that's not what we mean, I think is a really, really good best practice on what to do. The other federal change that we want to make y'all aware of on the next slide, as you're probably aware, during the middle of the year this year, we had a change to the Department of Labor's overtime rule. And this is impactful if you are utilizing, for example, a salary basis safe harbor notice within your handbook, which we certainly see very often, making sure that the white collar employee salary threshold has been updated for 2024. And again, it's going to change in 2025. We also know the highly compensated exemption is going to increase. It increased in 24. It's going to increase again in 25. And we know that there's going to be an automatic update every 3 years in these thresholds. And so if you are utilizing a policy that outlines the dollar amount, you need to be very, very specific around that. Otherwise, pointing to the dollar amount that is required by the U.S. Department of Labor is probably the best practice in this area to make sure that you're not always behind or reflecting the wrong dollar amount in your policies. And with that, I would love to kick it over to my colleague, Jean Wilson, who's going to take y'all to New York and New Jersey.
Thanks, Chelsea. We're going to start off with New York. And the big change here is the introduction of a paid prenatal personal leave. It's the first this kind of law in the country, and it provides 20 hours of prenatal leave per year. And the important thing is that this is an addition to the paid sick leave that you are already obligated to provide in New York. And it essentially allows people to use this leave for any kind of health services related to pregnancy. One of the aspects that we know may be challenging for some employers is that employees can use this time in 1 hour increments. So this is going to be one of those areas where you are going to need either a new policy or to put a section in your current sick leave policy that addresses this. In that same legislation, New York also amended its lactation accommodation. Prior to this, it just required unpaid breaks. It now requires employers to provide a 30-minute paid lactation break to employees. So we're going to need to maybe do some updating in your lactation accommodation policy as well. And then just mentioned here that the New York paid family leave maximum benefit amount has increased. Kind of next slide with respect to New York, one of the other big changes, and this is for retail employers only. There is a workplace violence prevention policy that now is going to be required. For those of you who have operations in California, you're probably already familiar with this, but it is going to require you to have a plan. Typically, we don't include these in the handbook, but we wanted to mention it here because it is a sort of drafted policy requirement that you're going to need to do. The DOL in New York will release a model plan. We imagine it'll be similar to California's, and our OSHA group really recommended that people follow along with that template pretty closely, and so I imagine the advice will be similar here. And then with respect to military leave, New York just expanded its existing policy to also include National Guard members in New York. Before, they just hadn't been covered by the statute. And one thing I wanted to mention here, because I think we overlook it a lot of times, is that this statute and most military leave statutes, including the federal law, don't allow you to terminate an employee who returns from military leave for 1 year following their return, except for cause. And so I just throw that out there because I feel like it's something that tends to get overlooked. And so we can go to New York City now. And so New York City actually pretty quiet this year, but they have introduced a workers' bill of rights that I just wanted to mention because you do need to let people give people notice of this when they're hired. And so just wanted to throw it out there. Also, for those of you who are maybe, 18 months since you last updated your handbook, New York City did add height and weight to their protected characteristics under their anti-discrimination law. And we're going to finish up in New Jersey, which also has been a pretty quiet year as well. Their paid family leave and temporary disability maximum amount is increasing, and there are some changes to the contribution rates that you'll want to take a look at. New Jersey did pass a domestic workers' bill of rights. This isn't going to apply to too many employers, but if you're a staffing or an employment agency that places domestic workers, there are some obligations that you'll need to be aware of. And, if you employ somebody in your own home, this is something you may want to take a look at as well, because, at doing that, you may become an employer under the statute just in your personal life as well. And then I thought it was interesting and wanted to just mention this discrimination guidance from the New Jersey Attorney General. And what the position that the Attorney General has taken is that if you are a New Jersey-based employer, the New Jersey anti-discrimination law is going to apply to all your remote employees, regardless of where they work. So even if they do no work in New Jersey at all, the AG has said these laws are going to apply to them. So I think it's something to just keep in mind. It may not require a policy change, but it does expand the kind of reach of your policy. And I am now going to turn this over to, I believe, Renata to talk about states out west.
Thank you so much, Jean. So we can start out with Colorado. Colorado amended its Privacy Act related to the use of biometric identifiers going into effect in July of 2025. So when we say biometric identifiers, that is defined as data generated by the technological processing, measurement, or analysis of a person's biological, physical, or behavioral characteristics, which data can be processed for the purpose of uniquely identifying an individual. And this includes things like fingerprints, voice prints, retina and iris scans, facial imaging, and that sort of thing, and any other unique biological, physical, or behavioral patterns or characteristics. So the major takeaways from this update is that beginning in July of 2025, employers can require employees and applicants to consent to the collection of biometric identifiers only for certain stated purposes. And those are things related to the access of physical locations and hardware and software programs, timekeeping purposes, and like safety and security of the employees, the workplace, and in certain situations, the general public. Now, employers can collect biometric identifiers for other purposes, but only with the voluntary consent of their employees. And importantly, employers are actually going to be prohibited from retaining biometric data for tracking purposes in terms of like an employee's location or like the amount of time that an employee spends using hardware or software programs. And this is important. There are some written policy requirements that are very specific to businesses that collect biometric identifiers addressing issues like retention and deletion in response to security incidents. Moving over to Washington, there have been some developments in the paid sick leave space over the past year. As you may recall, the rules were amended effective January of 2024, now requiring employers who use PTO policies to comply with paid sick leave requirements to specifically state that intent. There's also a payout upon separation requirement for construction workers. Moving into 2025, though, we have some new covered reasons for use and covered family members to talk about. So employees will be able to use their sick leave after the declaration of an emergency by a local or state government or agency, or such a determination by the federal government. And employees will be able to use their sick leave to care for their child's spouse and any individual who regularly resides in the employee's home. Or where the relationship creates an expectation that the employee care for the person and that individual depends on the employee for care. And to clarify there, family member does not include an individual simply because they reside in an employee's home. It's limited to where there's an expectation of care for that individual. In the paid family and medical leave space, back in June of 2024, the Bureau of Labor and Industries expanded the time period in which adoptive parents can take paid family leave. So if the employee chooses not to take their bonding leave within the first 12 months of the placement of a child and the adoption isn't legally finalized in that first year, the employee can now take any remaining paid family leave up to 12 weeks for bonding with their adopted child after the adoption is finalized. Moving into Oregon, there have been some substantial changes regarding family leave in Oregon this year. Effective in March of 2024, the Bureau of Labor and Industries made some regulatory changes to the rules implementing OFLA as well as the paid leave Oregon statutes. And this also impacted paid sick leave because employees in Oregon can use their paid sick leave for reasons covered under OFLA or paid leave Oregon. Employees can use their sick leave for purposes related to caring for a child of the employee who is suffering from an illness, injury, or condition that requires home care, regardless of whether that is a serious health condition, as well as pregnancy disability leave. Effective in July of 2024, there were some amendments to OFLA to change the calculation of the benefit year. So all employers must begin the benefit year on the Sunday before an employee's OFLA leave begins. That's going to be a requirement for everyone, or that is a requirement for everyone effective July of this year. And also effective in July, there's kind of been a substantial overhaul of OFLA in ways that will help prevent employees from stacking their OFLA and paid leave Oregon leaves, back to back. They no longer run concurrently, but the OFLA covered reasons are now limited to the bullets here. So that's, pregnancy, disability leave, sick child leave, bereavement leave, and adoption and foster leave. Now, as you may notice from the slide, the adoption foster leave is only in effect through the end of December of this year. And that is because effective January 1 of 2025, that's going to move over and be a paid leave Oregon covered reason for use. And then we'll wrap things up for the West with Utah. And if you joined us for our webinar last year, you may recall that we reported Utah had repealed its military leave law. They have reenacted that as of March of 2024. So that's providing protections now for active duty and reserve members of the armed forces, as well as National Guard and State Defense Force members. March was a busy month in Utah because that month they also enacted a bill prohibiting employers from compelling an employee to engage in a religiously objectionable expression that the employee reasonably believes would burden or offend their sincerely held religious beliefs. And there is a process in this law which went into effect in May where employers have to engage in a process for accommodating religious liberties. With that, I will pass the mic to Sarah to bring us up to speed on the Midwest.
Thanks, Renata. Well, we can start in with the next slide. Our Midwest states are relatively quieter this year compared to where we were last year with the proliferation of paid leave and paid sick leave coming in many places, but we still have a few notable updates to put on your radar for this year. So starting with Illinois, hopefully those of you who have operations in Chicago or Chicago employees have already reviewed their policies for paid leave and paid sick leave for compliance with the Chicago changes that went into effect on July 1st of 2024. If not, better late than never. So it would be a great time to make sure that we have incorporated those important changes that have been in effect now for a little bit, including the carryover changes on sick leave, the paid leave requirement, the accrual rates, among others. For those that use so-called unlimited PTO policies, we also have a unique payout requirement now in Chicago for those as well. On a statewide level, effective January 1st of 2025, Illinois' Human Rights Act is being amended to include family responsibilities and reproductive health decisions. Illinois is joining other states that have specifically added reproductive health decision-making to its anti-discrimination laws. And so depending on where you operate, you may want to give thought to whether that's added to a state addendum or even to a general EEO non-discrimination policy based on that update. Also effective January 1 of 2025, Illinois' Worker Freedom of Speech Act goes into effect. This is a captive audience law prohibiting employers from requiring employees to participate in meetings or communications from employers about religious or political matters. There is not a specific written policy requirement, but there may be reasons why adjustments to existing policies are needed or including this in a policy or handbook. There is, however, a posting requirement to be mindful of. We can move to the next slide, please. Moving into Minnesota. Minnesota has had a fair amount of notable employment legislative changes that are important to think through as you review your policies for 2025. So as you may recall from last year, Minnesota's statewide sick leave law went into effect on January 1 of 2024. There were clarifications made to that law that went into effect generally in May of this past year. So if it's been some time since you've looked at your Minnesota sick leave policies, now would be a good time to make sure that those updates are incorporated as needed. Specifically, bereavement leave is added as a covered reason for use of paid sick leave in Minnesota. There are some clarifications to employee coverage as well. Effective January 1 of 2025, and similar to what Renata just mentioned, I believe it was with Washington, all PTO or other paid leave that employers use in excess of the state sick leave requirements for absences for personal illness or injury have to meet or exceed the state sick leave law minimum standards. So that includes things like notice, documentation, anti-retaliation. So it's important to take a look at those policies if you have them and make sure that they're hitting those compliance targets as well. Cannabis testing. Minnesota updated its drug testing law earlier this summer to allow for oral fluid testing and to add specific provisions separating cannabis testing from drug testing. And so for those of you with operations in Minnesota may know, Minnesota has very stringent laws regarding drug and alcohol testing. And if you conduct those for Minnesota employees, now is, again, a really good time to make sure that those updates are reflected in those written policies that are required. The brief note here on paid family and medical leave for Minnesota, that law does not go into effect until 2026. But as you start thinking about the next year in 2025, we're going to want to start looking into our compliance plans for that PFML law going into effect in a little over a year. Pregnancy and prenatal leave in Minnesota. Minnesota updated its law to make clear that when an employee is receiving leave as an accommodation for pregnancy, employers must maintain their health benefits. So again, checking our policies and our practices to make sure that that is being done. And their amendments also clarified that time off taken for prenatal medical appointments does not reduce the time that's otherwise available under Minnesota's law for pregnancy and parental leave. And then finally, with jury duty, Minnesota's law was updated to clarify that employers cannot require employees to work alternative shifts if they're called for jury service, and to clarify that employers cannot take adverse action generally for time served on a jury. Moving into our next slide for Michigan, my home state, the main headline for Michigan coming for 2025 is, of course, its changes to paid sick leave that go into effect on February 21st of 2025. Many employers are not waiting until February to implement these changes and are looking at them now so we can have our policies in place as of the beginning of 2025. This law has a lot of changes from Michigan's existing paid sick leave law, including coverage, the accrual rates, the carryover, and it's allowing employees to use up to 72 hours of paid sick leave a year. So we strongly recommend reviewing your sick leave policies if you have operations and employees in Michigan to understand what modifications might be needed for those policies before the new year. And then finally, last slide on this section, I have a brief note about Missouri. Missouri is not a state that we typically see a lot of specific policy work required, but Missouri has a ballot initiative up next week to provide paid sick leave. So wanted to flag that for any of you that might have employees in Missouri to watch those election returns next week and see if we have a new sick leave law coming online. So with that, I'm going to kick it over to Chelsea for some California updates.
Yes, indeed. Thanks so much. And thanks to all of y'all for your updates so far. As y'all know, California always presents a lot of challenges for employers. It does tend to be one of the most employee-friendly states, if not the most. I know there are others that are moving to compete with it at this point. But, you know, we did have some developments this year. I think one of the themes that you can probably sense through all of the updates we've been providing so far is this didn't tend to be a very law-heavy year. Any election year typically is a little bit slower than years that are off cycle. And so with California, very similar. We did see obviously a lot of bills go through, a little fewer than half of those were signed into law. And so we did see a lot of activity, just not a lot in this particular area. But let me go through with y'all the ones that are most impactful for purposes of policies when you're updating your California handbooks and your California addenda, starting with the next page, which many of y'all probably are aware that there were some clarifications and some updates with respect to California paid family leave. Just as a refresh, you recall that paid family leave in California is sort of inaptly named. It's not a leave entitlement, it's just a wage replacement, but we do call it paid family leave for short. But there has been increases in the amount of benefits at the cap, as well as the amount that lower earning workers can receive from the state of California in terms of their PFL benefit. But the piece that is so important for purposes of policies is this fourth bullet point right here. As of January 1st, 2025, there's no longer an ability for an employer to require employees to take up to 2 weeks of accrued unused vacation before the employee is eligible for and can receive PFL wage replacement benefits. We see that in a lot of CFRA and FEMLA policies, and so we want to be very, very careful if we've got language in there that reflects, or even language in your notices of eligibility, rights and responsibilities, and your designation notices that require employees to use up to 2 weeks of time off before they are eligible for PFL. That sentence or two, whatever you have it as, needs to come out of your leave-related policies because you no longer have the ability to mandate that. Many employers did. Some just made it a choice, but for our purposes, we want to make sure that we're no longer mandating it and our policies no longer say that we do. On the next slide, I want to touch on SB 1137, which relates to our EEO updates, essentially. And this may require employers to make a couple of updates to their EEO, their harassment, their anti-discrimination policies in California. And as I'm sure you all recall, these are required to be written policies in California. You do have to have a very robust anti-discrimination, anti-harassment, anti-retaliation policy. This will include adding language around this concept of intersectionality, the combination of two or more protected bases. And this is the first jurisdiction to explicitly adopt this as a concept and give some clarifications on how it should be assessed. But we want to make sure that in our EEO policies, when we outline the protected categories, we're also referencing the combination of two or more of the protected categories. This also, we see in the EEO space under AB 1815, an expansion of the definition of race. We had it previously, it would say the historically traits historically associated with race, but we've removed the word historically, and we've also expanded that definition beyond hair texture and protective hairstyles. So it really is a little bit of an expansion that you'll need to flush out if you get into that level of detail within your EEO policy. I know because it is required in California, a lot of employers do that. And so it does, we want you to be looking at your EEO policies and make sure that it is compliant for 2025 by looking through SB 1137 and AB 1815. The next change, which is potentially the largest change that you're going to see in your handbook this year, is related to AB 2499 on victims' time off and victims' protection. So it's essentially reworked the concept of victim accommodation and time off in California by expanding the definition of victim, this new qualifying act of violence concept, which is a much broader definition to victimhood that we had in our previous laws and our previous policies. And so if you had in your handbook a policy providing accommodation protection and time off protection for those who may have been a victim of domestic violence, sexual assault, stalking, and other abuses or crimes, we now have changed that to qualifying act of violence, which has, like I mentioned, a much lengthier definition and is a much more inclusive than the previous language of that policy. There also is going to be a new notice that will be published by the state that will need to be part of your onboarding requirements as well. But if you did have a policy on this topic in your handbook, we want to make sure that it's updated to include this new language. Another really important aspect of this AB 2499 is it does kind of have buried in it that you are now allowed to utilize paid sick leave in California for jury duty and witness duty. And so very important, even though you're not going to find that in the paid sick leave law, we had some changes in paid sick leave this year, which we're going to talk about in just a moment, but it's not there. It's actually in AB 2499 with respect to this sort of expanded concept of victimhood. We definitely have the ability to utilize paid sick leave for jury service as well as when serving as a witness in court. And so we want to be aware of that and make those changes to the extent you are saying in a jury duty policy that an employee can utilize vacation, you want to include utilizing it using sick time as well. We also have clarification that this victim time off is going to run concurrently with CIFRA. So we want to make sure that if we were outlining that as something in addition to that, that we are making it clear that it does run concurrently with that at the end of the day. I also want to talk about the sick time updates on the next slide. SB 1105 that did have some paid sick leave expansion and clarification, especially in the agricultural employee space for those of y'all who may have some folks that work in the agricultural space. This also expands sort of the definitions of preventative care to make sure it's clear that employees are allowed to use paid sick leave to avoid smoke, heat, or flooding conditions that were created by a state or local emergency. So it really is just further digging into what preventative care is for these types of employees so that they understand what they can use their paid sick leave for. There also within the FAQs gives additional examples of what preventative care may be, including flu shots and annual exams. And again, I think a lot of people already understood that to be the case, but I think this is a really good way to clarify that and make sure that employees understand that if they need to take time off to go get a flu shot, that they can use their paid sick leave in order to do that. So I think that's a very important thing to kind of recognize as well. So again, not a ton in California this year, some very important things for purposes of updating policies. And so again, make sure you're reaching out so we can get your California policies, especially in the paid sick and the EEO and that domestic violence and victimhood protection policies. We can get those ready to go for 2025. With that, I will kick it back to Jean, who's going to carry us through New England.
Yeah, so thanks, Chelsea. So we're going to start out New England in Connecticut, probably has sort of the biggest change in the Northeast with the expansion of their paid sick time law. Connecticut was, I believe the first in the country to have a paid sick time law, but it was narrow in that you had to have 50 employees in Connecticut, and it only applied to service workers. After several attempts to get it expanded, they finally have passed the law. And as of January 1st, the law is going to apply to all employees. It is phased in over time. So only employers with 25 employees in Connecticut will have to implement this January 1. And then 11 employees, January 1, 2026. And then by 2027, it'll apply to everyone. It's a pretty standard 40 hours, 1 hour of sick time for every 30 hours worked. But it is different than, all of those things are different than what was there before, except for the overall amount of sick time that is available. One of the notable differences in this law from other paid sick time laws is that it specifically says that employers cannot require any documentation for use of paid sick time. We see that in the paid leave space, but it's rare that we see it in paid sick time. So I just wanted to call that out, and we'll need to make sure that any policy doesn't include that requirement. On the next slide, there's just a couple other small Connecticut changes. Maybe this is good news for people. This is, you can take this policy out. Voting time in Connecticut, when it was passed, had a sunset provision in it that it was going to sunset by June 30th, 2024. And that has happened. So we can do away with that policy. And then just in terms of the family violence leave law, that has been just amended to cover victims of sexual assault. And one of the reasons this is important is that in Connecticut, if you take up to 12 days of leave under the family violence leave law, you also can be eligible for paid family leave benefits. And so, just wanted to call that out because it expands it sort of in two ways, both with the family violence leave law as well as the paid family medical leave law. And then you can just see again that we are increasing the amount to $981 for the paid family and medical leave benefit in Connecticut. And now we're going to talk about my home state of Massachusetts, which had a relatively quiet year. Paid sick time as of November 21st, 2024, so just next month. They are going to expand the covered reasons for use of sick time, which will now include time off to deal with a pregnancy loss, unsuccessful assisted reproduction, or failed adoption or surrogacy. We're certainly seeing more activity in this space, but Massachusetts is the first state to cover this under their sick leave law. Most of you probably know that California and Illinois have bereavement leave laws that cover reproductive loss, but this is the first time we've kind of seen it put under the paid sick time category. With respect to paid family and medical leave, not a lot going on. The Supreme Judicial Court did just issue a decision confirming that benefits, so vacation time, sick time, those sorts of things do not accrue during leave. And I did want to just bring this up because there is an annual notice requirement in Massachusetts with respect to paid family and medical leave. And those are not available yet. The DFML will come out with new rate sheets that you can provide to your employees. And they usually come out pretty close to the beginning of November. So we should expect them pretty much any day now, and they just need to go out before January 1. And then if you are a little behind on updating your handbook or your addenda for Massachusetts, did want to just mention that under paid family medical leave, you now need to allow employees to use their sick and vacation time to top up their paid family and medical leave benefit. For those of you who are on the public option, you used to be prohibited from doing that, and now you have to allow it. And then these last three are not really policy ones, but just wanted to put on your radar that there are payday reporting and pay range disclosure obligations that are going to go into effect in 2025, as well as a new posting requirement for veterans benefits and services, We see this in a lot of states, but for some reason, Massachusetts has said this needs to be posted and distributed annually. So I thought I would just mention that because it's fairly unusual to have to distribute it annually. And then we're going to go all the way up to Maine. And they have a paid family and medical leave law that's going to start giving benefits as of May 1st, 2026. Wanted to mention it here because contributions do start as of January 1 this year. So you're going to want to have this on your radar, make sure ADP or whoever does your payroll is taking those contributions and then, you know, using this year to start to get ready for those obligations. And then we have a captive audience ban. This is similar to one of the laws that Sarah went over, which is essentially prohibiting employers from requiring employees to go to any kind of meeting or accept any information that's primarily about political or religious matters, which some people feel like it seems unusual. Really, the target of these laws is employers who are undergoing union organizing campaigns, so that you can't have employers can't require employees to come to meetings where they talk about why, you know, it might be a good idea not to join the union. And so then we'll go to New Hampshire. New Hampshire has now has a Crown Act. We're seeing this all over the country. I wanted to mention it here because, interestingly, New Hampshire doesn't has created a private right of action for discrimination based on protective hairstyles. So most of the time, this is kind of folded under the anti-discrimination law, and you would have to do, you know, either go to, you know, your state agency before you file a civil action in court. This law creates a private right of action, and so employees in New Hampshire do not have to file first with the New Hampshire Human Rights Commission, which is just unusual. New Hampshire also passed a lactation accommodation law that's going to go into effect in July of 2025. There is a policy requirement, so this is something you're going to want to have in your handbook. It's pretty standard in terms of what we see, and so it's likely that if you have a national lactation accommodation policy, that you will probably be covered. You may have a couple little things that you need to tweak, but this shouldn't be a big difference for people who have any kind of lactation accommodation policy right now. And then we have Rhode Island. Pretty quiet year in Rhode Island, except that under their temporary caregiver leave, which is essentially a paid family leave benefit, they've now expanded that to 7 weeks as of January 1, 2025, and then it'll increase to 8 weeks in 2026. So you'll need to look at your temporary caregiver leave policy and update those amounts. And then I thought this was another one that was interesting, not a policy thing, but there's an independent contractors are going to have to file a designation of status form with the Rhode Island Department of Labor and Training for each business where they provide services. And they have to attest that they're an independent contractor and not entitled to workers' comp benefits. And I just raised this because I think it's going to bring more scrutiny to independent contractor status in Rhode Island. So just something to keep on your radar if you have independent contractors in Rhode Island, because the information is going to the DOL essentially in Rhode Island. And then finally, Vermont. They have also passed a captive audience ban that went into effect in May of 2024. Vermont clarified their anti-discrimination law. Now it also includes hair types, textures, styles, and protective hairstyles. So similar to New Hampshire and a lot of other states. And Vermont does have a pay range disclosure law that's going into effect in July 1, 2025. So we just wanted to mention that so that you have it on your radar screen. And that is all there is for New England, and going to turn it over to Renata to talk about why you should have a handbook in the first place.
All right, great. So we just wanted to spend a minute or two for a brief refresh on, why having a handbook at all, and more importantly, maybe making it a good one is the best practice. In terms of the purpose of a good handbook, handbooks give us the best chance to introduce ourselves to our employees and sell them on all of the great things about us and our organization. They can help us communicate our expectations so we can hold our employees responsible and accountable. And we can also reduce inconsistency with them and the risk that managers might go rogue in deciding how to handle things on their own. In terms of why we need the written policies in the handbook, there are a number of policies that are required to be in writing. So this gives us an opportunity to provide those, as well as some other legal notices that might be required to our employees. And if anything has changed or gone wrong, we get an opportunity to roll out what we need to. Before you start drafting, you have some homework to do. On the next slide, you can see that when you're drafting policies, you will want to make sure that you are capturing all of the necessary information. You'll want to read the law, and then also, because these legislatures don't always do the best job of explaining themselves, any guidance, FAQs, agency opinions, case law, etc. And finally, what should we tell employees? Well, at the end of the day, the policies should tell the employees who it applies to, why they should care about it, what are they responsible for, and what are their rights under the policy, and also any limitations. So I will pass it back over to Sarah to talk a little bit more about Seyfarth's handbook team.
Thanks, Renata. So yes, a few notes about our handbook team and how we've helped employers. We can move to the next slide, please. We are fortunate to have a team of attorneys throughout our offices who've completed training on crafting and revising policies and handbooks. And we leverage template policies that we've created, our regional expertise, as well as particular subject matter experts like paid sick leave, paid family leave, our drug testing experts to stay on top of updates. So we're not reinventing the wheel each time, and we're more efficiently able to provide our clients with updates year over year. Next slide, please. What are these tools? What are they not? So these are completely customizable tools. They can serve as helpful starting points for clients that are looking for complete refresh or who are starting from scratch. And they can serve as guidance points for a more efficient review of existing policies and incorporating best practices. That said, they are not off-the-shelf products, and it's important to think through how these resources work with existing policies, your workplace culture, or desired goals with handbooks and policies. And they still do require individual tailoring to make sure that they are fitting within all of those goals, requirements, and what you already have in place. Next slide, please. So what can they do and how can we be of help? So again, we leverage the work that we're doing on the back end with our internal training, with updating our template policies every year to help our clients efficiently update what is needed during these annual reviews. And that translates to more efficiency and cost savings for our clients. And more often than not, we're not individually researching each law, creating a new separate policy from scratch, because we're able to leverage some of these existing tools to help with that. And so again, the way in which we are tracking these updates on a regular basis helps streamline these reviews and identify that we need updates to our Illinois anti-discrimination policy, for example, because we know we have these discrete new changes to update year over year. And so I know what many of you have all been waiting for then on the next slide, the CLE code. The CLE code for today's presentation, and you can scan that QR code that we have on the slide. It is SS7475, and the slides are going to be sent to participants after the webinar, but again, the CLE code is SS7475. And so now I will hand it back over to Chelsea to talk about trends that we're seeing going forward.
I'm actually going to then pitch it to Jean, because Jean's going to walk us through the trends, but very important. No worries.
Thanks so much, both of you. So just wanted to spend a few minutes talking about, the trends we're seeing and what we expect to see, continuing or, in the next year or so. So first, I'm always curious as sort of what is driving the trends. And, I think certainly it's always the priorities and policies of the current administration. So, the current administration, Biden came into office saying he was going to be the most union-friendly president ever. And I think that his support of the NLRB and the people that he's put in place demonstrates that. And we've seen a real increase in union activity as a result. We've seen the passage of the Pregnant Workers Fairness Act and Pump Act, and certainly the EOC is really focused on pregnancy and pregnancy accommodation. I think that, depending on what happens with the election, the current administration is interested in a national paid family and medical leave law. We really thought that there was no hope this was going to happen, really, I think anytime in our lifetimes, it felt like, given the inability of the Congress to get much passed, but there seems to be renewed interest. And I think if there is a Harris administration, we might see something. Still probably a long shot, but, could happen. There's a focus on limiting non-comp agreements and then also increasing the minimum wage. Harris, on her platform is to increase the federal minimum wage to $15 an hour. So those are some things that we're seeing now. And as you can see with the asterisk, all of that could change if, Donald Trump is elected. So we'll have to keep an eye out for that next week or whenever we eventually find out who is going to be the president. But, and as Chelsea mentioned with the NLRB, who's in office really does matter in terms of some of these issues. We've also seen a lot of social and political issues. Again, union organizing, things around inequality with diversity, equity, inclusion, and belonging initiatives, reproductive rights, and all of those things tend to spill over into the policy space. I think we're all still dealing with where people work. We're seeing a return to office for some people, but I do think that the remote hybrid world is also here to stay. So, I think there is still a balance, but also some policies that are needing to be tweaked now that people are coming back into the office. So if you are in one of those organizations, you may need to look at your handbook for some of that. And then technology, artificial intelligence is going to impact us in ways I think that none of us really can fully comprehend at this point, but it is something to keep your eye out for. And certainly we're seeing a lot of legislative activity in this area. So it's something to just kind of keep an eye on. And so just digging in a little bit to some other things that we're seeing. On the next slide, talking about accommodations. And this has been a really active area with the passage of the Pump Act, which led to a lot of lactation accommodation policies. And then the Pregnant Workers Fairness Act, which what I have seen in my practice and in talking to other people at the firm is a desire to have a separate pregnancy accommodation policy. I tend to be in favor of that because the standards that apply are different than they are for accommodations with disabilities. There's differences in terms of the type of documentation you can ask for, when you can ask for documentation, and also unlike with disability, you may in fact have to excuse somebody from performing the essential functions of their job if they will be able to perform them sometime in the near future, and that the excusing them is only for a temporary period of time. And by temporary, they tend to mean the length of somebody's pregnancy. So, I think we all have to look at our policies and not just a national policy, but I think we have to think about the state policies that have different standards and whether we need to add some kind of language to those state policies as well because of the new federal standard. And then just, as a result of COVID, we saw an increase in religious accommodation requests. And so we've seen a little bit more policy work in that area. And we also are now having domestic violence, reasonable accommodation laws being passed, or they're part of domestic violence leave law. So that's just another area to keep an eye on. And then I'm not going to spend much time here because I think we've talked about this a lot, but where are your employees working with, as Chelsea likes to call it, the great scattering over COVID and post-COVID. This, employers having employees in states where they never had employees before continues to be an issue. And, this slide kind of covers the things that you'll want to think about in terms of compliance with those state laws. And then next slide, and a bunch of the speakers have touched on this. We're seeing expansion of protected classes with respect to anti-discrimination laws. Some of them are listed here, but again, it's something to keep an eye out. And as I think Sarah mentioned, really looking at whether you want to incorporate some of these into your national policy or keep them just in the state addenda where they apply. And so, and then the other thing in this area is that we're also seeing a continued move towards getting away from a severe and pervasive standard for harassment, so that you don't necessarily have to prove that something is severe and pervasive. So just also another thing to look at your discrimination policies in particular states to make sure that that standard isn't reflected in those policies. And then this next slide is just some quick hits and stuff that we've probably, for the most part, touched on. We're seeing an increase in captive audience laws, increase in interest in including reproductive loss in bereavement policies. As I mentioned, Illinois and California have bereavement leave laws that include this, and Massachusetts just added it as a sick leave reason. We're seeing but some laws around data privacy, social security number privacy, and electronic monitoring. And I bring it up because often those are required policies, so good thing to just keep your eye on. And then finally, the last thing is just gender neutral language. I'm still seeing a movement towards this to have most policies be gender neutral. And I am going to turn it back over to Chelsea to talk about two of the most challenging handbook issues and to close us out.
Thanks very much, Jean. Just in terms of continuing trends, I did also want to touch on paid sick leave because we really do get probably more questions on how to deal with paid sick leave policies in our handbooks than almost any other topic, specifically when you are a multi-state employer or multi-jurisdiction employer and you're trying to come up with concepts that are one size fits most or one size fits all. And this, unfortunately, is not getting any easier. As Jean touched on, there may be a world in our lifetime where we see a federal solution to this, but as of right now, we are still just seeing more states, more cities passing these laws. Sarah touched on earlier in her presentation that Missouri has paid sick leave on the ballot. Missouri is not the only state that has sick leave on the ballot this year. We also are seeing a sick leave potential ordinance coming in Alaska and in Nebraska. They're voting on that next week as well. And so it'll be interesting to see in those three jurisdictions who aren't really known for having a lot of law, we might get paid sick leave in three more places as of the beginning of next year, just depending on what happens at the ballot box next week. And so we will definitely continue to see development in this area. So keep your eyes peeled for that. And another trend that we're predicting to be a little bit unpredictable is on our next slide, which is paid family and medical leave. I'm sure many of you know that just a few years ago, we had paid family leave in maybe one or two states, and then it just kind of grew like wildfire, and we really started seeing these take off and now have 11 mandatory PFML laws, 2 voluntary PFML laws. We've got several states that are coming online in 2026. We're certainly expecting to see more of this, and the likelihood of federal legislation certainly would increase depending on what happens with the election next week. So this is an area where we don't anticipate we're going to get any slowing down, and really just being aware of the law well in advance, so that even if you don't need a policy quite yet, you know when the contributions need to start so that the policies can be put in place, and you will already have taken all of the steps that were necessary to get yourself in good shape. And with that, I want to thank all of y'all for attending our webinar this year. We really enjoy being able to present this information to all of y'all. If you asked a question in the Q&A and we didn't get a chance to get to it, we tried to get to many of them as we were swapping through. We'll try to get back to you offline separately because we're going to hang on to that Q&A. You also have all of our contact information, so if you have any questions for us or need any help specifically, this is how you're going to be able to reach out to any of us. But with that, we want to definitely thank you for your questions and for listening. We encourage you to reach out so we can help you get your handbooks into a less scary state for 2025. But hopefully all have a wonderful Halloween and a great holiday season. Thank you, Sarah, Jean, and Renata for your assistance with this.